Good day, viewers, and a very warm welcome to this episode of the Indian Lawyer Legal Tips. Today's topic is trending, the surrogacy laws in India. I'm Sushila Varma, advocate and chief consultant, bringing to you this brief overview on surrogacy laws in India. Let us first begin with the historical background. For years, India was prominently positioned on the world map as a hub for surrogacy, attracting individuals from all parts of the globe. This was largely attributable to the fact that costs of surrogacy were comparatively much lower in India. Apart from that, there was no proper legal mechanism or a legal environment that would make some checks on the entire process. Commercial surrogacy found de facto legalization in 2002 through guidelines issued by the ICMR, that is Indian Council of Medical Research, which however lacked statutory backing and comprehensive regulatory teeth. This unregulated environment, while offering a pathway to parenthood for many, soon revealed a darker and murkier side. The terms baby factory and surrogacy consumerism became an increasingly associated term for India, bringing out several scandals in the fray. Significant ethical and social concerns came to the forefront, primarily revolving around the exploitation of economically disadvantaged women who became a prey and, because of their financial desperations, agreed to become surrogate mothers. Now let us examine the law. The law in India is the Surrogacy Regulation Act 2021 that received presidential assent on 25th December 2021 and came into force in January 2022. The primary objectives, of course, of this act would be to regulate the surrogacy practices in India. First, it aims to constitute a National Assisted Reproductive Technology and Surrogacy Board at the national level and state boards at state levels to regulate the practice and process of surrogacy. It also prohibits commercial surrogacy. Apart from that, it prevents the exploitation of surrogate mothers or children who are born through surrogacy. This involves ensuring informed consent, safeguarding health, and protecting the rights of the child. And it also ensures that ethical practices are followed in surrogacy conducted in India. Now let us see the eligibility of who can be an intending parent under this act. There are two categories. The first is an intending couple, that is a couple that is married and are Indian citizens and who are incapable of producing a child. Then there is an age criteria, that is for a female partner 23 to 50 and for the male 26 to 55 years of age. This couple has to have a medical indication, that is they have to possess a certificate of essentiality which they have to procure from the district medical board that certifies infertility or inability that prevents them from conceiving. And finally, they should not have children of their own before they go for surrogacy, and if they do have, it is only in an exceptional case, that is the child that they have is handicapped or suffering from a life-threatening disorder or is mentally or physically disabled, because of which they want another child. The second category of persons who can adopt is what is known as intending woman. An Indian woman who is a widow or a divorcee can also avail of surrogacy. She must, however, be between the ages of 35 and 40. This provision offers a path to single motherhood for specific demographics, though there are certain conditions that have to be met. Now let us see a very interesting aspect of this act, that is the exclusions. This act explicitly or implicitly excludes several categories of individuals from accessing surrogacy in India. These include foreigners, overseas citizens of India, that is OCI cardholders, LGBTQ plus individuals, single men, including unmarried or divorced men who do not fall under intending woman category, and couples in live-in relationships. These exclusions are amongst the most criticized aspects of the Act and form the basis of several ongoing legal challenges that are happening at the highest court in India. Now, what are the eligibility requirements for a surrogate mother and how does the Act protect her? The first thing that the Act does is they say that in order to uh, become a surrogate mother, the woman has to be eligible, the woman who is eligible has to satisfy certain conditions. The first being close relative. Now, she has to be a close relative of the intending couple or the intending woman. This is a defining and often controversial feature of India's surrogacy model. The practical difficulty of finding a willing and eligible close relative is a very significant challenge. Then we have what is the marital status and own child. That is, she must be an ever married woman and must have at least one biological child of her own. Thirdly, she has to be within the age of 25 to 35 years. Fourthly, a woman can act as a surrogate mother only once in her lifetime. Then, of course, she must have a certificate of medical and psychological fitness to be a surrogate mother from a registered medical practitioner. And probably, I would say one of the most important aspects of her eligibility is informed consent. That is, her written and informed consent is mandatory. She must be in a position to understand the risks that she's taking, and she must be agreeable to do the same. Lastly, but I would say very, very important, is that the intending couple or the intending woman must get an insurance coverage for the surrogate mother, and that should last for 36 months. That is, not only during the pregnancy period, but also the postpartum period. This, I would say, is a critical safeguard for the surrogate's health. Now, let us examine another aspect of this Act, that is, what rights does the Act guarantee for children born through surrogacy? I would say the law would recognize them as children of the intending parents or intending women, and they will have all the rights that normal children would have, that is, equal rights to property. They would be recognized in society as the child of the parents, etc. Now, let us see what are the penalties that are in place because of the violations of the Act. The first is commercial surrogacy. Undertaking, offering, promoting, or advertising commercial surrogacy or associating with it in any form is a serious offence punishable under the law. Penalties can include imprisonment for a term of 10 years and can also include a fine of up to rupees 10 lakhs. Other offences that are recognized by the Act would include exploiting the surrogate mother, abandoning or disowning the surrogate child, selling or importing human embryos or gametes for surrogacy purposes, and conducting sex selection. Now, let us understand what we mean when we say gametes, and how recent amendments regarding donor gametes have impacted intending parents. Gametes are an organism's reproductive cells. The question of whether donors' gametes, that is, eggs or sperm, can be used in surrogacy procedure has been a focal point of regulatory adjustments and legal debate for several years now. On March 14, 2023, a significant shift occurred with a Gazette notification of March 14, 2023, which amended the Surrogacy Regulation Rules 2022. This amendment stipulated that an intending couple undergoing surrogacy must use both their own gametes, that is, the wife's eggs and the husband's sperm. The use of donor's eggs or donor's sperm by a couple was effectively prohibited. Obviously, this created a hue and cry. An intending woman, that is defined as a widow or divorcee undergoing surrogacy, must use her own egg cells and donor sperm. So these things obviously restricted people from becoming parents. The Supreme Court, in a matter that came up before it in January 2024, held that the stringent March 2023 rules could not be upheld, and they gave seven couples who were before them permission for getting into surrogacy with the help of donor eggs or donor sperm. Following these interventions in February 2024, the Supreme Court also decided to redirect all applications seeking similar reliefs to the high courts where the intending parents were living. Now let us see another aspect of this Act. For an intending couple, the primary rule remains that they must use both gametes, that is, the intending couple's eggs and sperm. However, an exception is now carved out if the district medical board certifies that either the husband or the wife constituting the intending couple suffers from a medical condition that necessitates the use of a donor gamete, then surrogacy using one donor gamete, either a donor egg or a donor sperm, but not both, is permitted. A crucial condition is that the child to be born through surrogacy must have at least one gamete from the intending couple. Now, let us see the different changes that this Act has gone through since 2021. This has been placed on the screen below because this Act has been in the public limelight for some time and has been going through several, not only legal battles, but also several changes. Now, let us see what is the position of the courts and how judgments have shaped the current law. I would say that the first judgment that should be brought before the audience is baby Manji Yamada's case. This is a baby in which they had requested an Indian woman to act as a surrogate mother for a Japanese couple. But before the baby could be born, the Japanese couple divorced. The biological father was desirous of taking custody of baby Yamada, but the laws in Japan did not allow it. So the matter came up before the Supreme Court of India. Ultimately, the Supreme Court, balancing the equities, allowed the grandmother, that is the father's mother, to adopt the child, and the child was sent to Japan. In another case, Jan Balas versus Anand Municipality, 2009, Gujarat High Court judgment, twin children were born to an Indian surrogate mother commissioned by a German national. Germany refused to grant citizenship to the twins as German law did not recognize the commissioning father as the legal father under such circumstances without adoption, and the surrogate mother was an Indian. The central legal question presented to the Gujarat High Court was whether children born in India to an Indian national surrogate mother with a foreign national as the biological father were entitled to Indian citizenship by birth. The court ruled in favor of the children on the principle of jus soli, that is, right of soil, and the children were granted Indian citizenship. These pre-act landmark cases primarily grappled with the consequences of an unregulated, often commercial, and frequently cross-border surrogacy landscape. Their focus was largely on child welfare, determining parentage, and addressing citizenship issues that arose in the legal vacuum. The chaos and human distress evident in these cases were significant drivers for the eventual enactment of the Surrogacy Regulation Act 2021. Now, let us examine a very important aspect of this particular law and probably the reason why it's so much in the limelight. That is, what are the ongoing legal battles related to the Act and what might be the outcome? The first, I would say, is the donor gamete issue. The Supreme Court stayed the highly restrictive March 2023 rule that had banned the use of donor gametes for couples, granting relief to specific petitioners on medical grounds. This prompted a governmental review and led to a more nuanced February 2024 amendment, which allows for the use of one donor gamete by a couple if medically certified. The Supreme Court also facilitated wider access to justice by directing that such pleas should be heard by the High Courts in the future. In a Kerala High Court judgment, Rajita PV versus Union of India 2025, the petitioner was a woman who was ineligible for surrogacy because she had completed 50 years. She insisted that till she was not 51, she should be entitled to have a baby through surrogacy. The court, however, rejected it, saying that they had to stick to the guidelines that were laid down in the Act. Now, there are challenges to the exclusivity or eligibility criteria. A significant number of petitions currently before the Supreme Court of India, such as the petition filed as Maheshwara MV versus Union of India, writ petition Civil 309 of 2025, deals with the issue of excluding single and divorced men from availing surrogacy, while there are other petitions which have been tagged together along with this for comprehensive redressal. All the petitions challenge the Act's restrictive eligibility criteria, which exclude various groups from accessing surrogacy, along with the overall constitutional validity of both the Surrogacy Regulation Act 2021 and the Assisted Reproductive Technology Act 2021, which is being contested in the case of Dr. Arun Muthuvel versus Union of India in writ petition number 756 of 2022. The arguments in these petitions are typically grounded in fundamental rights, asserting that such exclusions violate Article 14, that is right to equality, Article 19, that is fundamental freedoms, Article 21, that is right to life and personal liberty, which have been interpreted to include reproductive autonomy, the right to found a family, and dignity. The Act's exclusion of women who already have children from accessing surrogacy, irrespective of custody arrangements or subsequent medical conditions preventing further pregnancies, is also the subject matter of challenge. Let us now see some other aspects of surrogacy. I would say one of the aspects is the adequacy of compensation, which has come into question by petitioners before the Supreme Court, where they feel that the compensation provided to the surrogate mother is not sufficient. The outcome of these cases is pending, and it is only a matter of time before we know exactly what the Supreme Court will decide. Now, there is another aspect of this act which has started worrying a lot of people, and that is the close relative requirement. Now, close relative means close relative of the intending couple or the woman. One of the most significant hurdles for the intending couple is in isolating or finding a close relative who is willing to act as a surrogate. Not only that, the age criteria of 25 to 35 years is another thing that comes in the way. The definition of close relatives is such that it does not encompass too many people. There are, of course, ethical issues that if you are a close relative, you might be coerced or emotionally blackmailed to become a surrogate mother, and that is something that the Act tries to protect. They feel that there should be voluntariness of consent, which is essential in order to become a surrogate. Now let us see what are the arguments for the ban, that is protection-centric view. The primary justification for the ban is the prevention of exploitation of economically vulnerable women who in the past were often coerced and induced by financial need and finally were cheated. It also aims to stop the commodification of women's reproductive capabilities. The ban aligns with ethical arguments that commercial arrangements can lead to the objectification of surrogate mothers as mere wombs for rent and can raise concerns about the sale of babies. I think now what one really needs to do is to see how the courts interpret the different provisions of the law and whether a ban should or should not be given under this act. Having said that, I think I would like to conclude by saying that the Surrogacy Act is definitely a very important piece of legislation under Indian laws. And I would say it represents a landmark legislative intervention in India for reshaping the practice of surrogacy in India. It signifies a determined effort by the state to move away from the largely unregulated commercial surrogacy, which had garnered international attention, but also raised profound ethical concerns towards a framework prioritizing humanism, regulation, and the protection of vulnerable individuals. The Surrogacy Act can be seen as India's ambitious attempt to navigate an ethically complex and socially sensitive domain. It represents a significant shift from an extreme of largely unregulated commercialization to another extreme of highly regulated and restrictive regulations. The ongoing legal challenges, the evolving rules, and the persistent debate suggest that the current framework is still in the process of seeking a sustainable equilibrium. Now let us see how the Supreme Court deals with these issues, and we will definitely bring up this topic once again to you. Dear viewers, thank you for watching us regularly. I would also like to caution you that what we have said in this particular episode is only legal tips or informative and cannot be deemed to be legal advice. If you have found this video useful, please like, share, and subscribe and help us to reach many more people who can be educated about Indian laws. Thank you. Until we meet next week, goodbye.